So members of council who are participating remotely, please remember to have your camera on during the meeting so that the chair may be able to see your hand up.
There you go.
There you go. Good afternoon and welcome to the regularly scheduled meeting of the Council of the Municipality of Thames Centre. It's Monday, January the 16th, 2003. And we are in the council chambers at 4305 Hamilton Road in the village of Dorchester. The time is 1:02 and I'd like to call the meeting to order. Are there any additions to the agenda?
There were no additions to the agenda.
Okay, thanks. Any disclosure of pecuniary interest? Okay, seeing none, then any announcements? Okay, then what we'll do now is we'll proceed to the presentation with Mr. Mescarin from Aird and Burles LLP. And if you're ready to begin, John, you go right ahead.
Madam Mayor, members of council, thank you. Happy New Year to all of you, and thank you for having me back today. I am ready to present. If you don't mind, Madam Mayor, I'm just going to share my screen, and then I'm going to pull up the PowerPoint slide for you to see. I'm hoping I'm going to pull up the right one here. Please tell me if you can see it on your full screen. It should say open and closed meetings.
I'm not seeing it just yet.
It's clicked into my screen. I had it on my screen, but I think it's now clicked in.
There you go.
Okay. Yeah, I just saw it come in. Thank you very much for your indulgence there. Again, thank you very much for inviting me back today. I'm pleased to talk to you about open and closed meetings. So why am I talking to you about open and closed meetings? Why is this topic so important? Well, as you know, at the local level, the most important decision-making body are yourselves. You are an elected assembly and you make decisions on behalf of the municipality. In fact, you're the sole decision maker on behalf of the municipality for all purposes. You are the only body that can actually bind the municipality through your actions and your determinations. And so that's why open and closed meetings are an important topic. Now, when I say you are important because council's decision-making body, you make decisions under Section 5.1 of the Municipal Act, one of the most important sections. So if you don't read the Municipal Act on a day-to-day basis, I would suggest reading Section 5 and 239 after today. So Section 5 says, the powers of a municipality shall be exercised by council. It's enshrined in legislation. And how are council's actions determined? Well, by the enactment of bylaws, or in other cases, by resolutions. Section 5.3 says the powers of municipality shall, it's imperative, shall be exercised by bylaw, or unless otherwise specifically provided. Okay? You, as individual members of council, have no unilateral authority to actually do much of anything. Madam Mayor, even you, as the chief executive officer of the municipality, you have very limited, very, very narrow, circumscribed executive powers. Council members themselves, unilaterally, have no authority to do anything that binds the municipality. That includes, of course, giving directions to staff. And it's so important that I talked a little bit about it earlier when I come, that the province has deemed it appropriate that not only does the municipality pass a policy that indicates how you are to have a relationship with staff, which is typically the municipality is governed by two aspects. The governance arm, which is council to make the executive decisions by bylaw at open meetings, or by the administrative actions that staff implement through the direction of council. And how do they do that? Well, typically, almost exclusively by council's determinations in setting a policy, bylaws, and passing resolutions and approvals, making decisions at open council meetings. So that's why this meeting today, this training, I think is so important. So my introduction, without further ado, the open meeting rule applies to all of your meetings. In fact, the open meeting rule applies to all municipal councils throughout Canada. Not all of them have this particular rule as is set out in section 239 sub 1, but almost every jurisdiction in Canada, even outside of Ontario, has something that's equivalent to the open meeting rule, basically saying that you as a council, you have to exercise your powers in an open public forum. And there's the rule in 239 sub 1, except as provided in this section, all meetings shall be open to the public, okay? So there's an inherent exception built right in, but the general rule is that all meetings shall be open to the public. The purpose underlying that was stated very eloquently by and succinctly by the Ontario Court of Appeal in Brantford versus Mantour. The open meeting requirement has these two important rationales: increase public confidence in local government and prevent secrecy in municipal decision-making. Here, Madam Mayor and Council, is my outline of where I plan to go today. By the way, when I had first gotten the meeting invitation, it said the meeting was from 1 to 4, and I just assumed that I was being given 3 hours. I now completely understand that council actually has a formal meeting today and you have other business. So I will attempt to limit my time to 1.5 hours. But what I didn't do is I didn't go back and delete a number of slides from my presentation. I thought they would be a good resource for you in the future. So Madam Mayor, what I've done is I've left my slide deck intact. So you'll find that there's probably more information that I'm able to get through today, and I'll explain what I'm omitting. And hopefully you can use the slide deck as a bit of a resource going forward. So that's why I've left it in this purpose, in this manner. So we're going to talk a little bit about the open meeting rule. What constitutes a meeting? That's important. Electronic meetings, just like we're having today. Myself and 2 of your council members are here on a hybrid meeting, which is now specifically authorized by the Municipal Act. Then I'm going to be spending a good deal of time on the closed meeting exceptions. So while the general rule is, of course, that you have to have everything in an open public session, the rule itself is subject to an inherent exception, which says, except as provided in this part. And there are 14 separate subject matters that you as a council can decide to go into camera. For 12 of them, 2 are mandatory, and I will explain all that. I'll talk about the procedural requirements when you decide to go into a closed session, the fact that you are entitled to vote, and what you can vote for and what you can't vote for in a closed meeting. I'll talk a little bit about record keeping, just a little bit. Your clerk is probably much more well-versed than I am. Because I am your closed meeting investigator, I will speak about closed meeting investigations. Any person can file a request to have us investigate whether you conducted yourself appropriately in accordance with the law at a closed meeting. I'll talk about the reporting, particularly reporting out. And then at the end, I'll talk about some common problems and some best practices for you. So that's the outline of where I'm going. And Madam Mayor, I have no problem if anyone would like to interrupt me while I'm speaking and ask a question. That's no problem at all. I also respect the fact that you'd probably like to stay on time. And so if you'd like to save your questions to the end, that's fine with me as well. So I will proceed. The open meeting rule, I've shown it to you. It's in section 239. Once more, except as provided in this section. So any exceptions have to be found in 239. All meetings shall be open to the public. Now, meetings means meetings of council, meetings of local boards, however that's defined in the section of the Municipal Act in section 1(1). It's a very broad definition of what a meeting is and what a local board is. And committees of either of council or local boards. In order to be a committee of council, you have to have at least 50% of the members who are members of council as well in order to be a meeting of council. If it doesn't meet that threshold, then the committee or whatever body is constituted, could be constituted by council, is not subject to the open meeting rule, okay? So council is, local boards are, and committees, which comprise of at least 50% of the members of the committee are members of council, or in the case of a local board, members of the local board. That's what is a body that's subject to the open meeting rule. So what you should know is it's a statutory rule. Prior to 1922, the Consolidated Municipal Act of 1922 that brought in a lot of strictures and prescriptions to municipalities, there was no requirement for a council to hold its meeting in an open public forum. The media at the time, the print media, had attempted several times to apply to court to say, hey, the meetings should be open to public. And the court kept coming back saying, well, that's a requirement that's statutory based. There's no common law rule. If there's not a rule put in place by statute, then the meetings can take place in a public forum, in a private forum. Prior to 1994, meetings were generally closed based on the type of meeting rather than the subject matter of the meeting. So it said meetings of council. And what was happening is councils were deciding to do a workaround the open meeting rule by just creating committees. Committee of the whole, and the committee would not be subject to the open meeting rule. And that was all changed in 1994 through the imposition or the implementation of Section 55 of the modern rule of the open meeting rule in the Municipal Act by the Planning and Municipal Statute Law Amendment Act in 1994. There were a number of white papers and a number of recommendations there as to how to efficiently run the open meeting rule. That is essentially the current version of the statute with refinements made by Bill 68. And I'll highlight two significant amendments that Bill 68 made to impact the open meeting rule. The City of London case versus RHJ Holding, probably the most famous case, went all the way to the Supreme Court of Canada. And this is what the court said. The open meeting requirements reflects a clear legislative choice for increased transparency and accountability in the decision-making process of local governments. The democratic legitimacy of municipal decisions does not spring solely from periodic elections, but also from a decision-making process that is transparent, accessible to the public, and mandated by law. When this does not happen, when things happen in secrecy, it undermines the democratic legitimacy of the municipality's decisions. This was an infamous case that ended up going all the way to the Supreme Court of Canada. And what happened in this case? The City of London Council was very concerned about student housing around Western University. And what the council decided to do is to consider the possible implementation of an interim control bylaw under Section 38 of the Planning Act. Now, an interim control bylaw, if you don't know what that is, it's an extraordinary remedy that allows a municipality without notice to anybody, including the property owner, to pass a bylaw without notice to freeze development on the land for up to 1 year, which can be extended for up to 2 years. It's an extraordinary remedy that a municipality has. And the City of London was deciding whether it could use this authority to control, regulate student housing around Western University. What council did is for 2.5 hours, it discussed the matter in an in-camera meeting. And then in the span of 8 minutes came out and passed 23 bylaws, including the interim control bylaw. Well, that was challenged as being invalid for having breached the Municipal Act's open meeting rule. And the court held that's true. That's what you did. You cannot decide to go in camera to discuss a planning matter. Section 38 of the Planning Act is the planning matter. All planning matters have to be discussed in an open public forum. And the court said it doesn't matter that the municipality didn't have to give notice. What the purpose of the open meeting rule is to show the local electorate local democracy in action. So the whole purpose is not to have closed door session meetings to discuss things that councils are not allowed. So that was the City of London case. So meetings. The definition of meeting is set out in 238. Now, when you look at the slide here, you'll see that I've underlined the first part of it. That used to be the sole definition of meeting. It used to say meeting means a meeting. That's essentially what it used to say. First of all, very unuseful because it's circular. A meeting means a meeting means a meeting, right? But you actually, terrible legislative drafting as well. You typically don't use the very definition of a word, the actual word that you're trying to define in its definition. So this was an advancement of by Bill 68. The reason that the province put this in is, and you'll see when I get later, I talk about the default closed meeting investigator. In 2006, through the Bill 130 amendments, the Ontario Ombudsman was given a little bit of a door opening where the Ontario Ombudsman could have some jurisdiction over municipalities. The jurisdiction that was given was the Ontario Ombudsman was made the default closed meeting investigator if a municipality had not appointed an investigator itself. And the Ontario Ombudsman was very eager to get in here and was looking for a way to find a number of contraventions. And the Ontario Ombudsman decided not to apply the meaning of meeting as had been already, in a sense, set out through a number of court decisions, Southern Inc. versus Hamilton Wentworth, Southern Inc. versus Ottawa, that it set out a number of criteria for when you have a meeting. The Ontario Ombudsman said, well, anytime there may be a gathering of some members of council, and they lay the groundwork for some decision, well, that constitutes a meeting. The only problem with that is that the Ontario Ombudsman did not read the law in Ontario. That's not what the case law had said. And I really do like the new definition of meeting because it aligns with the established jurisprudence from the Ontario Divisional Court and the Ontario Court of Appeal. There are now two conjunctive components to what constitutes a meeting. First of all, you have to have a gathering, but the gathering has to have at least a quorum of members who are present, okay? That's something that the Ombudsman didn't even think was important. In order to have a valid, lawful meeting, you have to have at least a quorum of members. And the conjunctive, that means you have to have the second component also in place, is you have to have the members, the majority of the members of the meeting, of the council, actually talk about something, discuss something, deliberate on it. It has to be regular council business, or it has to be within the decision-making authority of council, and council has to materially advance the business or decision-making of the council. That's when you have a proper meeting. So each of the components, quorum, the general rule in section 237 sub 1 is a majority of members constitute a quorum. In your municipality, you have 5 members, you need 3 members in which to have quorum. Okay. If you have 2 members, it's not a meeting. It can't be a meeting because it doesn't meet the first requirement. Interestingly enough, and you may or may not know this, and I can't remember if I said this in my first education session earlier in the term, but you can recalculate the number of members who will constitute quorum if a sufficient number of members actually declare pecuniary interest under the Municipal Conflict of Interest Act. So your council has 5 members. You need 3 members for quorum. But what happens if 3 members happen to declare pecuniary interest under the Municipal Conflict of Interest Act? You've only have 2 members left. The Municipal Conflict of Interest Act actually says you're entitled to have as little as 2 members. You can't have only 1 member standing or 0. In that case, the legislation does allow the council to make an application to the court for some relief. So the general rule is majority. In your case, there's 3 members. Material advancement, well, material means a significant advancement. So the business or decision making, well, something that forms a normal matter, issue, question, concern that is considered by council. Bottom line here is there must be something more than what the ombudsman thought was important, which is laying the groundwork, which he actually said, if something is mentioned, well, that's laying the groundwork. Well, I don't think a mere mention of something can constitute material advancement. That's what the new definition says. Okay, you are entitled. Yes.
Excuse me, Mr. Mesri. I believe that Councillor Heenan was raising his hand.
Oh, okay. I'm sorry, Councillor Heenan. Through you, Madam Mayor, I'm looking at my PowerPoint presentation. I'm not looking for the raising of hands. I'm really sorry about that.
Councillor, did you have a question or? No. All right. Hard to tell. Okay. Sorry for the interruption. Go ahead.
Not at all. Allowed me to take a drink of water. So electronic meetings. Most people forget electronic meetings were proposed in Bill 130 for the amendments to the Municipal Act back in 2006, and it didn't go forward. What the legislature did is it allowed some I didn't think very helpful electronic participation. A member of council could participate in the meeting, but couldn't be counted towards quorum and couldn't vote. So very, very limited. Then you have the pandemic hit. Well, for those councils who hadn't delegated their powers to somebody to administratively make decisions, it was a problem because with social distancing, with small gatherings only permitted, you couldn't have council meetings. So this would have really put a nail in the coffin of municipalities to make decisions. So the Municipal Emergency Act allowed municipalities for the first time to meet in a virtual setting and make decisions and vote. And that was permitted by municipalities. The municipalities could change their bylaw through a virtual meeting to allow virtual meetings to continue during the state of declaration. Well, lo and behold, the province found that this actually wasn't a bad idea. I think many municipalities found that electronic meetings were not a bad way to foster democracy. And therefore, the COVID Economic Recovery Act put in place the authority for municipalities to continue to have to have meetings in a virtual or, as we're having today, in a hybrid setting. So what I want to tell you about, though, is be very, very careful. You are entitled to meet in a closed setting in an electronic format, but only if it's properly and duly constituted. Be very, very careful in your municipality, and I say this to all municipalities, to not meet in an other than properly constituted meeting in some sort of electronic format. The Ontario Ombudsman and a number of closed meeting investigators, including us, have said that it is inappropriate for council to attempt to get together to make decisions before they're supposed to by meeting either through a teleconference call, through phone chat lines, through social media, through Zoom, Teams, FaceTime, Skype, choose your weapon, and even through email correspondence that is emailed and there's communications and responses back from members of council. I put just 3 examples there of reports from the Ontario Ombudsman, where the Ontario Ombudsman has said emails back and forth between council members discussing municipal business can constitute an illegal closed meeting. So please be aware of that. You should interpret Section 238, the meeting matter, in light of the purpose and legislative intent to increase accountability and transparency. Members should not be emailing or texting each other or messaging or somehow communicating in an electronic format. And I always say to members of council, just be very careful. If you're going to use emails to communicate with members of council, just don't. Just don't do it, because you don't know. You could set off an illegal meeting without even knowing it. You could perpetuate it. I'll give you an example. Not going to pick on you, Councillor Heaton, but let's say you wanted to advise council that in a couple of weeks, something very important was coming to council, something that's very important to you. And you might want to say something like, council members, for information purposes only, and I don't want you to email me back. I don't want to hear from you. But this is a very important matter, and it's coming up at council. I urge you all to be there because I'm going to be there, and it's very important to the people that I represent in the municipality, right? Now, by doing that, Councillor Heaton, you've put a number of strictures. Please don't email back, don't respond. This is for information purposes only. But what happens if another member of council decides to send that email to somebody else and there's a bit of a dialogue between them? And what happens if one of them sends it out to someone else? All of a sudden, you've got 4 members of council that are participating and discussing matters potentially, and that could constitute an illegal meeting. City of Hamilton apparently seems to do this with some regularity. There have been 3 closed meeting investigation reports over the last year and a half by the Ontario Ombudsman, all saying you cannot continue to do this. You cannot email one another and start discussing matters. Okay, so please be careful about email, text, anything in writing that goes to more than one member of council. You won't know. It might be disseminated to other people, and it may come back and people start understanding who's deciding to do what or where someone may be thinking of moving on a particular matter. Please be careful of that. Closed meetings. Now, this is probably the bigger part of the today's discussion, closed meetings. As I said before, the general rule, open meeting, except that the public may be excluded if an exception applies to the open meeting rule. There are 14 subject matter exceptions that are put in. There were 10 put in 1994 through Section 55, and those have been increased recently by Bill 68 that added 4 new closed meeting exceptions in 2018. The exceptions in sections 239.2 and 239.3.1 are discretionary. So 12 of the exceptions in which you can meet in a closed setting are discretionary. You don't have to meet in a closed setting, but you may choose to. In general, the rule is in legislation, if there is a general rule, the law dictates that normally it gets interpreted broadly, liberally, and purposively in order to give it effect. And if there are any exceptions to the rule, then they're typically interpreted narrowly and restrictively, okay? That is the case with respect to the closed meeting exceptions. In general, the courts and the Information and Privacy Commissioner have interpreted the open meeting rule very broadly and have interpreted, in general, the closed meeting exceptions narrowly, okay? That's important for you to know. I will now set out each of the each of the 14 exceptions. And I want to speak just briefly about them. You'll see, Madam Mayor, members of council, after I set these out, I have a number of slides here that go through very specifically each and every exception under the open meeting rule in sections 239 sub 2, sub 3, and sub 3.1. I will only talk about a few of them because we don't have the time for me to go through all 14, but I will highlight certain things in each of them. And I will leave you the slide deck for your resource if you'd like to ever have reference. Okay, so here are the first three. These have been in place since 1994. I'm going to talk a little bit about them. And at some point during your term of council, you will get some pressure from some residents in your municipality or others to not go into a closed session. That you'll hear this: you should be doing everything in an open public forum. Everything. I want to highlight to you that the provincial legislature, in its wisdom, has thought it appropriate to allow certain exceptions to the open meeting rule. And I think those exceptions are, in some instances, very important. So when you have the pressure to, no, you have to discuss this in an open forum, you have to turn your mind, is that in the best interests of the municipality? Is that in the best interest of all the residents of the municipality? Okay, that's the test. That's what you have to consider. Why should the discussion take place in closed? Is it better that it takes place in open? Okay, so I'm just going to highlight the first three for you. The security of the property of the municipality or local board. Security here means protection, and property, it means not just real property, even though, interestingly enough, the Information and Privacy Commissioner for many years had interpreted the word property here in a very narrow sense, as if it was only real property, which is a little silly because if you look at the Municipal Act, when the Municipal Act wants to speak about real property, it actually uses the words real property. It didn't in this case, and it's beyond me why the Information and Privacy Commissioner had embarked upon a number of orders defining property here as only real property. It's now corrected that determination. Property means real property, personal property, and intellectual property. Anything essentially that belongs to the municipality. Just think of a trademark, or in your case, I suppose, an official mark or something that's copyrighted. Those are intellectual property rights that you have, and you may not want just anyone else using them. For instance, if someone were to start establishing their business and using your municipality's logo, well, how appropriate would that be? They're misappropriating your branding, your logo. That would be wrong. And this would allow a discussion of how do you protect that. For instance, maybe deciding to create that as an official mark for the municipality. So to give it some copyright protection, okay? Number two, B, personal matters about an identifiable individual, including municipal employees. Okay. Notice that it doesn't say personnel matters. This is something that I always run across. People seem to misread that all the time. They seem to think it's HR related, personnel matters. It's not. It's personal matters about an identifiable individual. So if it's an identifiable individual, it means some person, an individual person, a real person, can be identified. So just because you have a meeting that says something about the CAO, there's only one CAO at your municipality, and so that person could be identified. Personal matters, people ask me this all the time. Does it mean personal information? That's something that's protected under the Municipal Freedom of Information Protection and Privacy Act. My view is, yes, I think it clearly means at least personal information, but they don't use the term personal information in this case. It's personal matters. My view is, I think the legislative drafters wanted to be a little more broad. They didn't want to just include personal information as defined in Section 1 of MFIPA. My view, and I think the view of the IPC as well as other closed meeting investigators, is that personal matters means something, but means something more, but it also includes personal information as defined in the Municipal Freedom of Information and Protection of Privacy Act. Okay. Again, there's going to be a number of slides following my recitation of just the text here, and there'll be all of this discussion will be in there, so it'll be left for you. Okay. C, a proposed or pending acquisition or disposition of land by the municipality or local board. So proposed or pending, it means something that's real and discernible. It doesn't mean that you're allowed to have a meeting and go, I don't know, maybe in 10 years we might want to purchase some lands to expand this facility, or we might want to dispose of some. That's purely speculative, and that's not what is applicable here. You have to have a real discernible pending or proposed acquisition of land. Okay, now just let me double back here. B, just think about it. It's important. All of these are important in certain instances. So again, as I said, you may get some pressure at some point by a member of the public or more than one. You have to have this discussion in open public session because we need to hear about it. It's important to us. Okay. Well, let's just say a member of council receives information from someone that a senior administrator has done something terribly wrong. They've acted completely inappropriately. I'll leave it to your imagination what that can be, right? Okay, senior administrator. Is it important for the public to know that? Yeah, perhaps. What if the information, lo and behold, is incorrect? What if it's false information? What if it's misinformation and you decide we're not going to go in camera? The public should know how atrociously bad this member of staff has acted. You could damage the reputation irrevocably of that person. Okay, so might there be a good reason why at least the initial discussion of council dealing with information that's like that, incendiary information about the deplorable behavior or at least the allegations of a member of staff? My view is absolutely yes. And I would recommend in instances like that, that council at least have the initial discussion in an in-camera setting. Okay, because why? You could damage the reputation of the person. You could hold yourselves up liable for a defamation claim. Potentially. Okay, number C, or clause C, a proposed or pending acquisition or disposition of land. Let's say your municipality would like to foster the cultural well-being of the municipality, right? And what you'd like to do is perhaps establish an art gallery, and you found the exact perfect place for it, but it's not owned by the municipality, so you have to acquire it. Okay, so let's just say the land on which you have found the land, which is the perfect place for the art gallery that you'd like to establish. Let's just say that that person who owns the land is someone who is very much valued by the municipality and the community, may have donated to your campaign, may have been someone who brings value to the municipality in some way. Okay. Would it be important for that person to know that potentially you would like to acquire their lands? Absolutely. Do you feel that perhaps you might have a personal obligation for that person donated to your campaign? Absolutely, you might feel that. Put that aside, because why? Well, you have to act in the best interest of the municipality. If you were to disclose the fact that the municipality may be interested in buying that person's land right there, won't that ratchet up immediately the value that the municipality will have to pay for the land? Potentially, yes. And is that in the best interests of all of your residents? Absolutely not. Okay. Remember, when you take your seat as a member of council, you represent every constituent in the municipality. I know you have a ward structure in your municipality. You may have been elected by wards. 3 of you have. Well, you don't just represent the members of your ward. You represent the entire municipality. And while it may be eminently important for your constituents in that particular ward, for instance, to be able to have an art gallery there, they are not people who are solely subject to that interest. It's important for all the members of the municipality. That's why it may be important for you to go into an in-camera setting to consider the possible acquisition. What if it was the disposition of land, and you wanted to take as a bottom bargain price, $10,000 for a piece of land? Well, guess what? Someone may bid for it if they know that. So is it important that you go to in camera to consider that? Yes, it is. Okay. Doesn't mean you have to every single time. You have to make a determination. I'll speak about that. So here are the next 4. Labor relations or employee negotiations. Interestingly enough, I remember I told you that typically the exemptions are dealt with narrowly. Oddly enough, Clause D, labor relations, employee relationships, negotiations, is one of the exceptions that have been interpreted quite broadly. Litigation or potential litigation, including matters before administrative tribunals like the OLT. Would you want to have the open discussion about your litigation strategy with your solicitor? Probably not, right? F is a similar advice that is subject to solicitor-client privilege. Remember, the solicitor-client privilege belongs to counsel, not to any individual member. And you may get a very sensitive, important advice that you're entitled to get as solicitor-client privilege advice, and perhaps you don't want to disclose it to everybody else. And then a matter in which the council, board, committee of another body may have dealt with a meeting in a closed setting. I dealt with this a couple of times last term. Of course, the Emergency Management Civil Protection Act requires that there be closed meetings to deal with emergency matters. That is the type of meeting that is possibly encompassed here. So if there was a matter considered there in a closed meeting under that statute, which is required, you can, as your counsel, consider the matter in a closed setting. Okay. The exception for closed meetings under the Police Services Act, I think it's section 35 sub 4. The Police Services Act can go into an in-camera meeting to consider matters that are sensitive. You don't have the same exception for municipalities. But if the Police Service Board has that discussion and it would like to give information to you as the municipality, you can receive it and keep it confidential, and you are allowed to continue to have discussions in a closed setting because the Police Service Act allowed it to come. Otherwise, it would defeat the purpose, and you may not be getting that information from the Police Service Board anymore. Okay, so those are the prior existing exceptions. Here are a number of new exceptions. All of these were added by Bill 68. And in my view, they were added to align the provisions that speak to exceptions to disclosure under MFIPA, to align them with the provisions in the Municipal Act closed meeting rules. So information that the province or the federal government or a crown agency of either of them give you in confidence. For instance, they would like to give you funding to do something. And they often will say to you, we're giving it to you. This is confidential information. Why? Because the federal provincial government would like to make the big splashy announcement themselves. They don't want you to go and wreck the party for them. What do you think the chances are if you decide that you're going to go and deliver the news before them? Well, they probably won't like it, and maybe they'll think a second time about providing you with grant funding in the future. So that's one. I aligns with Section 10 of MFIPA, which is the third-party information protection. This exception here has been put in place to protect persons who the municipality does business with and give you information that may be scientific, technical, commercial, financial, or otherwise. And for them, it may risk their contract negotiations and their ability to negotiate in the open market if this information were to be made public. So I think this is a really good one. So for instance, I tend to do almost all of my work for municipalities. I very, very, very rarely act against municipalities. So as a municipal lawyer, I tend to file a lot of proposals under RFP for legal services, for closed meeting investigation, integrity commissioner services, things like this. And I don't mind disclosing to you, municipality, what my rates are, what any discounts may be, what my work plan is, all of that information. I don't mind that you have in order to make your assessment, whether you'd like to give us your business. I certainly don't want that information, though, to go to anyone else. If my competitors found out about it, all they have to do is bid $10 less, right? And they'd have a better setting. What happens if I offer a discount to one, but not to the other municipality? They could find out about it. And that's very precarious. So I think this is good, and it aligns with Section 10 of MFIPA. Now, if you're wondering, what about the information that we have as council? Well, the same type of information, except for labor relations, right? Because that's subject to a different exception. Under J, if you have any of that information, scientific, technical, commercial, or financial, that belongs to you, and you can monetize that information in some way, then you're allowed to have the discussion in an in-camera setting. And then finally, the last one is anything that you're doing, if you're undertaking, you're applying them to negotiations that you will be carrying out, you are allowed to protect that information. And again, both of them on this page are aligned with the non-disclosure requirements or exceptions in MFIPA. And I think that's a really good thing, because before we're trying to do these crazy machinations and workarounds in order to be able to consider in a closed setting or otherwise information that you would normally be able to take if it wasn't done in a meeting setting. But you could get it, and other people couldn't get to that information. All of the exceptions that I've just shown you, these ones right here, these 11, they are all discretionary. So you do not have to go in camera to consider any of these, but you may go in camera. And I think I've impressed upon you, I hope, that there are some really good reasons why you may want to go in camera to discuss some of these matters, okay? You don't have to, but you may want to. Okay, now these slides here, you'll see I go through each and every exception that I just showed you, and I give you a quick snapshot, sort of a bullet point list of things that you need to be aware of. I will not go through some of these because I've essentially gone through several of them. I won't spend my time going through them, but you'll see that each one of these, sometimes there's one or even 2 or 3 slides on each of the specific exemptions. Okay, so I'm going to go through, I'm going to skip ahead here, and I'm going to talk about the additional exceptions. Here are the 2 that are mandatory. There are 2 closed meeting exceptions that council has no discretion, it must deal with it. The first one is if council itself is the head and hasn't delegated the authority or responsibility under MFIPA for an FOI request, well, then you have to consider it in a closed session. Otherwise, you'd be disclosing what the request is, who made it, and all of that. So that can only take place in a closed session. But just remember, there's very few instances you've probably already delegated your authority to be the head, the responsibilities to your clerk or your deputy clerk or privacy officer. The second one is if there's an ongoing investigation with respect to a closed meeting investigator or the ombudsman. If that's in fact the case, often the ombudsman or a closed meeting investigator will provide the municipality with a final draft of a report that it has completed in order for council to consider it and give any feedback. That, of course, needs to be considered only in a closed setting, because if it were to come in an open setting, then that's a bit of a problem, because then everyone would find out what it is. And maybe council has a number of comments, recommendations, or submissions to make to either the ombudsman or the closed meeting investigator with respect to any report or findings that are contained in that report. So that has to remain confidential. And finally, the last one, and we're not meeting here today under this specific authorization, but council can have a closed meeting in order to consider a education or training matter like we're having today, but you don't have to. You can have this in an open public setting. There is a rule, though. You cannot, if you meet to discuss education and training, first of all, the only reason that you can go in camera under section 239 3.1 is to discuss the educational aspect to it, and you cannot materially significantly advance the business or decision making of the council. Okay, so there is a report on this. It says there are an infinite number of topics that could potentially form the subject of an education session. It must be clear that the purpose of such meeting relates to education only. Okay, we recently wrote a report. It's a public report now, Niagara-on-the-Lake. They had a closed meeting session with a lawyer and a facilitator to be educated on the Planning Act and certain changes that were being made to proposed to the Planning Act. Well, the problem there is at some point, the facilitator deviated and instead of educating council, started talking about certain options that council could exercise in order to make different types of planning decisions. So they were actually advancing the business and decision-making of the council. Now, interestingly enough, they said, oh, well, we're also going in to get advice on a solicitor-client privilege basis. Well, but you can't have an education training session that encompasses something else. You need separate meetings for that. So again, the only purpose that you can use this for is education and training, and it actually has to be bona fide education and training, not just that in guise, okay? So what happens though, if you go in camera and you need to discuss something, but all of a sudden you're slightly deviating away from something else? It happens. One of the rules are, and your clerks will be well trained to keep you on the straight and narrow. Anytime that you start deviating a little bit, the clerk will often say to you, or your CAO, council, we're here to talk about X. You can't start talking about Y. However, the case law, and this is the case from St. Catharines, talks about when matters are inextricably connected to one another. It said it would be kind of silly to have to parse out meetings and have to stop and go, uh-oh, we're kind of moving now, but we have to talk about this because this is more of a cohesive, logical discussion that we need to have before we can continue to discuss the other matter. There is a little bit of limited authority there for council to continue to be at the closed meeting and yet still talk about things that are slightly outside of it, as long as you say that there is a nexus. There's still a connection to what you've been talking about in closed, okay? That's just a little bit of leeway just to recognize the practicalities of going, uh-oh, we have to now get out of closed, adjourn, go back into open, then go out of open, pass a resolution, go back into close. It just seeks to assist in that. Procedures and voting. Remember I said that the primary number of exceptions, 12 of them are all discretionary. Well, you have to pass a resolution to go into camera, in camera. It is mandatory for a council or a local board or committee, if it wants to go into an in-camera setting, to pass a resolution to do so. Okay, you have to indicate that the meeting is being closed and the general topic that is to be considered. There's one little additional caveat if it's a closed meeting for education and training purposes. So what happens? Like, what are the requirements? Well, the Farber and Kingston case says the resolution to go into closed session should provide a general description of the issue that maximizes the information that's available to the public, while at the same time not giving away the very purpose that you're going in camera. So remember, I talked to you about the closed meeting exception under 239(2)(c), a pending or proposed acquisition of land. So if you were to disclose in your authorizing resolution that you're going into camera to talk about the pending acquisition of land at 123 Main Street East, you've pretty much given it away, right? So it says you're supposed to try to articulate as much as possible what should be, what is going to be discussed in camera, but without giving away the very purpose for which you're entitled to go in camera. This is where your clerk and your CAO will help you very much. Typically, the law is that a resolution that says we're just going in camera to talk about personal matters dealing with an identifiable individual, typically that will not suffice. You're supposed to give a little bit more. In that particular instance, I'm not sure what more you could give. You might be able to say, the person is a municipal employee, or the person is a municipal consultant or a third party. I suppose you could do that. But if you give away the person's name, then you've identified them, So you have to always bear this in mind. Voting. People seem to think that there is no voting allowed. Well, there is voting allowed at a closed session. A meeting may be closed for the taking, if there's a taking of a vote, if both of the following requirements are met. The first one is you're actually in the closed session for a proper purpose, right? You are in closed session to deal with one of those exceptions in 239 to A to K, or is it K? Yeah, I think K, or under 239 3.1, okay? So those you're allowed to be in camera. Then the vote is for a procedural matter or to give instructions or directions to officers, employees, or agents of the municipality. Now, I've seen this, and I actually had to write an opinion on this several years ago. Some closed meeting investigators have made an illogical conclusion on this. They look at this and it says the vote is for a procedural matter, okay? So what they read is, well, you can't make a substantive decision at a closed meeting. And I say, phooey to that. That can't be. It's just not right. For example, you're in a closed meeting. You're discussing litigation. You're meeting with your lawyer. You've been sued for $10 million. And your lawyer says, you know what? I think I can get you a resolution here for a $10,000 payment. It'll cost us more to litigate this than $10,000. Will you go for it? Now, in order to give instructions or directions to your legal counsel, or if it's your CAO on the purchase of lands, or for your clerk, or your planning director, whoever, don't you have to make a substantive decision? Of course you do. You couldn't give them instructions unless you made a substantive decision. So I see that many councils have been told, we cannot make substantive decisions. You cannot vote on a substantive matter. And that's just crazy, because of course you can, provided that you're giving instructions to someone, okay? So please keep that in mind. You are entitled to vote. People say, well, can we raise our hands, or do we have to have recorded votes? Well, no, you don't have to have recorded votes. You can act by consensus, or you can have a vote. You can do that for something that's a procedural matter, or for giving instructions or direction to officers. What you can't start doing, though, is making substantive decisions where you're not giving instructions to anybody, and it's not for a procedural matter, okay? And the conjunctive requirement is, of course, it has to be for a proper closed meeting matter, okay? I'm not really sure I agree with this decision. I wanted to show it to you. The Farber case said, you know what? If council goes into in camera and does something wrong and they take an improper vote, it's just a procedural irregularity. I really have some problem with this, and I think the reason that the Court of Appeal came to this decision is, in this particular case, what they did is they went in camera and they actually took a vote for an improper purpose. They shouldn't have taken the vote the way they did. But it was corrected afterwards when the council came out and actually held another vote in an open session, and thereby corrected the fact that they had had an illegal vote. So I think the court's decision here is tainted with that particular fact situation. And I think it's unfortunate, because my view is, if council goes and actually votes on something improperly in camera and then acts on it, I'm not sure that that would be a correct thing to do, simply because they can come out and vote on it afterwards. And I think, again, this particular decision may have been influenced by the fact that the court knew that the council had come out and voted in an open session. Attendance and record keeping. Who can attend a closed meeting? I'm asked this all the time, and I'm always surprised. Unless your procedure bylaw says otherwise, and I apologize, I didn't look it up to see if it did, but typically they don't, even though I was surprised several years ago. I had a council who wanted to discuss the possible termination of their CAO. Well, the CAO said, I'm entitled to come to that meeting. And I was asked the question, and I said, well, why would he think that? And they go, there's something in our procedure bylaw. Well, I said, well, bingo, he is entitled then. If you've got it in your procedure bylaw, you've set the ground rules, right? What I said to council is, of course, you could always waive the application of the procedure bylaw, which you can do by, I think there was a supermajority vote there of 2/3. So you could possibly do that, but typically the rule is, all members of council who are entitled to be at the meeting, and when I say that, you're typically entitled to be at any meeting, except under Section 5(2) of the Municipal Conflict of Interest Act. You are not entitled to attend a closed meeting where you've declared a pecuniary interest. Or, my view is, if you're otherwise disabled. So if you have indicated that you are biased, you're irrevocably biased on the matter. You said, I have a closed mind, I'm not going to change my mind on it. Well, you've disqualified yourself from considering the matter. Or you may have declared a non-pecuniary interest. You might have a personal or private interest that's non-financial in nature, and so you shouldn't be able to attend the closed meeting. Otherwise, all members of council are entitled to attend, even if the members of council would like to talk about you. So if and this happened to me last term, we were looking after a member of council who the rest of council was, in a sense, beating up on, and she was told by the clerk, you can't attend the meeting. And she said, why? She said, well, because we're going to be talking about you. That's not a valid reason. No, not at all. The other person who has to be at the meeting is the clerk, or a person who's been designated in writing by the clerk, because you need a record keeper. Any other person that council would like to have at the meeting is entitled to attend if council so chooses, with one caveat. Sometimes the closed meeting exceptions have been determined to be for the protection of the bargaining power of the municipality. So something like negotiations and the proposed or pending acquisition of land, that the purpose of those closed meetings exceptions are to protect the bargaining position of the municipality. So if you invite the person whom you're selling the property to, or you're buying it from, that would be wrong, because all of a sudden they'd be at the meeting and there's no bargaining position to protect any longer. So subject to that, you are entitled to invite anyone that you would like, and it's typically at council's pleasure who gets to attend and who doesn't get to attend. Remember, the clerk always has to attend, or a person designated in writing by the clerk or the deputy clerk. Anyone else is pretty much at council's pleasure. Record keeping. Well, I've been asked this. I was actually asked this when the Ontario Ombudsman took over the default closed meeting investigation, and he said, you know, if we're doing an investigation, it would be really assisted if we could have an audio or video recording of the meeting. And we said, hold on, yes, you can. And yes, it definitely would assist in the record keeping for a closed meeting investigation. But is that why you would want to record it? Or is there another reason? Because if that's the reason, well, what's the purpose of having a closed meeting? To have a full and frank discussion away from everyone else. So would it possibly derogate from council members being able to fully and frankly disclose and say what they'd like at a closed meeting if they knew it was being audio or video recorded? Undoubtedly, it would help a closed meeting. It would. But is that the real purpose of it? I'm of two minds. As a closed meeting investigator, yes, an audio or video recording, primarily video, is very helpful. That means you don't have to actually go and interview however many people were at the meeting in order to understand what may have happened at the meeting. You may just need to watch the video, right? Otherwise, it might be a he said, she said, and people's recollections aren't really clear. And so you might end up having to interview every single person who's at the closed meeting. So does it help? On one hand, it does. Does it somehow erode the full and frank discussion? Potentially. So I'll leave it to you. I don't necessarily think it's a bad idea. I'm not sure it's a good idea always, but it's something that's a policy decision that council can make. What about the contents? What has to be in a closed meeting record? The Ontario Ombudsman has set out a short little document, and it says a proper closed meeting record should include all of these things. So your clerk typically will keep a record of all of these things. Then where the meeting took place, when it started, adjourned, who chaired the meeting, who was in attendance, because you need to know in case someone was not supposed to be there, right? When people came and left, right? What were the substantive and procedural matters that were discussed, including reference to documents? Were there any motions, and were there any votes taken or directions given? Okay, these are all things that should be kept in a closed meeting record in order to assist in case there's ever an investigation. So, going to investigations, as of January the 1st, 2008, through amendments put by Bill 130, any person may request an investigation of whether council complied with the open meeting rules in Section 239 or its own procedure bylaw in having a closed meeting. This can be done by an investigator if you've appointed one, and you have, so thank you very much. Or if you hadn't, it would be the Ontario Ombudsman. And I've already talked to you about some of the issues that some municipalities have had with the Ontario Ombudsman. So it deals with both aspects. So did you comply with Section 239? And did you comply with your procedure bylaw? Okay. The procedure, well, an investigator can exercise such powers as the municipalities have assigned. Typically, the municipality doesn't assign much. I usually carry out my functions just typically as set out in sections 239.2. I look at things like impartiality, independence. I conduct everything in confidence, just like an integrity commissioner investigation, not like a public inquiry where everything is public. Everything here is done confidentially. The name of the person who is requesting the investigation remains anonymous. By the way, I should have gone back. It says a person. It doesn't say an elector. And the reason being is, municipality does business with many people, some of which who are not electors. So it would be very narrow if they had put the word elector here and had limited the ability to do this to only electors. So they added person. Person at law means a corporation, but it doesn't mean something that's unincorporated. For instance, a ratepayer group that's not incorporated. Okay. The other thing that the investigator should do is should have a credible investigation process. So should have a certain set of guidelines in how it conducts its investigation. Ours is posted for LAS. We're the closed meeting investigator for LAS for about 140 some municipalities. We have a certain, I think, 12 list of things that we ask for, and then the way we conduct our investigations. As I said, investigations conducted in public and private. The investigator may hear or obtain information from any person that they think fit. We are entitled under Section 19 of the Ombudsman's Act, that is given over to municipalities, the authority to compel any officer, employee, or member to give us information and produce documents. We have a duty of confidentiality. There is no ability for someone to get to this information through MFIPA because there is an override. There is no review of the investigation. Someone cannot challenge the investigation except if they argue lack of jurisdiction. That's the only grounds that someone can challenge an investigation, for lack of jurisdiction. The investigator, just like the integrity commissioner, is not a compellable witness, and any information or documents that are supplied are privileged and are not disclosed. And that makes sense. If we're doing a closed meeting investigation, any information that the municipality may provide to us is confidential. If we were to go and disclose that in our report, then it would completely take away from the closed meeting exception. So everything has to be done in a confidential setting. Steps on the closed meeting investigation, here they are. I'm not going to go through them in any detail. Typically, there's a formal request that's filed by a complainant. Complainant remains anonymous. We typically do the first initial intake and review and the assessment. Do we have jurisdiction to look at this? Is it actually something that deals with a closed meeting and something that deals with Section 239 or the procedure bylaw? If it doesn't deal with any of that, then we have no authority to go and conduct any kind of investigation. The municipality, if it didn't come through the municipality initially, we notify them, typically the clerk. We then undertake our field investigation, which we gather information, we review the record, we may need to interview any witnesses, members of council who were at the meeting, any recollections or any other documentation. We then make a determination of findings and prepare a draft report. I think most closed meeting investigators do that. They prepare a draft report, not just preliminary findings. And then that's typically provided to the municipality on a confidential basis, where the clerk then can present the draft report to council for its consideration and any submissions or representations it would like to make with respect to the matter. If there is a contravention of the open meeting rule, it's reported, and council must pass a resolution on how it intends to address the report, and the report must be made available to the public. Okay, here it is, right? It's right there. Reported recommendations. If there is a finding of a contravention, then there has to be a report, and we may make recommendations. For instance, everybody at the municipality needs to receive closed meeting training, for instance, or council needs to be very mindful of its requirement to always pass a resolution to disclose and other reasons why it's going in camera, or whatever other things. Unlike an integrity commissioner investigation report, there are no sanctions or penalties that result from the breach of the closed meeting rules. The enforcement really is through the publication of the report. And what the province did in subsection 12, the very bottom quote there, is because it saw that many municipalities were actually receiving reports showing that there were contraventions and recommending certain actions, and municipalities were not doing anything about it, the province said, well, you know what you have to do? You actually have to pass a resolution to indicate how you will address the recommendations. So that's a mandatory requirement. So So when you get, if you are unfortunate enough to ever get a closed meeting investigation report that indicates that there was a breach of Section 239 or the procedure bylaw, typically we'll have recommendations, and then you have to indicate as a council what you'd like to do with it. That's one of the reasons why the report is often given to you ahead of time, right? So you can consider what resolution you would like to pass. Reporting out. There is no requirement in the Municipal Act that the record of any meeting, open or closed, be received or adopted by council. So reporting out varies significantly from municipality to municipality. And what I've said is there is no bright line test for every single matter that you discuss in camera, how you possibly report it out. In my view, in the interest of accountability, transparency, and openness, it is appropriate for council to report out to a particular degree what may have happened in an in-camera setting so that the public understands that there was a closed meeting and that something emanated from that. The Ontario Ombudsman says, and he's said it in these two reports, but in a number of other ones, I encourage councils to report back on what occurred in camera, at least in a general way. In some cases, the reporting might consist of a general discussion in open session of the subjects considered in closed session. This might be similar to the information in the resolution authorizing the session, together with any information about decisions, resolutions, and directions given to staff. In other cases, however, the nature of the discussion might allow for considerable information about the closed session to be provided publicly. So you might be able to have the discussion in closed session, and you may be able to come out and give further information to the public, right? Sometimes you may not be able to give much. It might just say, council went in camera to discuss solicitor-client privilege advice and gave directions to its solicitor or to its CAO, right? That may be sometimes all you can report out. Again, there's no statutory requirement to do so. It is often included in procedure bylaws, but sometimes not as well. Approving notes, a record of the closed session. Well, notes or records of a closed session can be adopted by council in closed session. I know this has been debated by clerks who have often said, no, it has to be done in an open session. I don't think so, because what happens if you have questions? What happens if you want to actually discuss? You may end up disclosing something that was supposed to be confidential. So I think that the notes or records, not necessarily the minutes, but you may call them that, of the closed meeting can be approved in camera, right? The record should accurately and precisely reflect the decisions and directions while yet protecting the confidentiality of the information. And those notes and records will remain confidential. If by chance there's a question later on about the approval of the meeting minutes of the closed session, then council is entitled to go back in camera on the original basis on which they went in camera to discuss that. Okay, doesn't happen that frequently. My conclusions, and I've hopefully left a little bit of time if you'd like to ask questions. Here are common problems with the open meeting, closed meeting rules. Typically, the problems arise like this. There is no closed meeting exception that's applicable. I dealt with this just over the weekend. A municipality wrote to me and said, you know, we have this document. I'm sorry, I can't tell you what it is. We have this document, and these senior officials would like it to be dealt with in a closed session. And the clerk said to me, I am hard pressed. I cannot find a closed meeting exception that applies. Do you know if this or this is applicable? And I did a little bit of research, and actually I found one case that talked about both of the possible exceptions that the clerk was thinking of utilizing. And both of them said, no, you can't protect that particular information under those two headings. So I went back to the clerk. I said, I can see why you're hard pressed to find an exception that applies, because I don't think any apply. They would like to have it in camera. It is sensitive information. It's information that maybe the public could possibly misuse, but I don't think it squarely and neatly fits within any of the exceptions. So just because something is controversial, just because something is sensitive, something is contentious, doesn't mean that you can go in camera to discuss it. Sometimes you say you're going in camera for one thing, but you actually discuss something else in the closed session. That's a problem. And some people will pick out on it. They'll pick out that you went into camera because that was disclosed, but then when it comes out, something different is reported out, and sometimes there is a misalignment there. There is a failure to comply with any procedural requirements, passing the resolution properly. There is improper voting at a closed meeting, improper, insufficient record keeping. There is a failure to report out. Now, again, I just want to be clear, the reporting out not subject to a statutory requirement. It may be in a procedure bylaw. And typically there's a lot of hay made of it. The municipality is just trying to be secretive, but there's actually no other penalty that may be imposed. And finally, education and training is not the sole purpose of the meeting, right? It's said it's supposed to be for education and training under 239 3.1, but actually you start doing a whole bunch of other things and possibly advancing the business of the municipality's decision making, even though you've said, oh, we're only in here to get training and education on this subject matter. Finally, my best practices are provide notices of when the upcoming closed sessions may be. Many municipalities preset them, and they say that they'll always be 1 hour before the regular meeting of council, or they'll be held after the council meeting. That's fine. That doesn't mean you have to have the meetings. It just means that you've given the public maybe some notice on your calendar that there may be something there. They'll know when it may be. And if you know that there's going to be a closed meeting, well, let the public know. Otherwise, secrecy abounds, and then there's rumors, hints, allegations, innuendo take over. Pass a clear resolution regarding the purpose or purposes of the closed meeting. You can have more than one. You can go in camera to discuss solicitor-client privilege advice, litigation, and possible disposition of land. You can do all three of those if the subject matter is actually all three of those. Select the correct closed meeting exceptions that apply. Stay on topic during the discussion and the debate at the closed session. Again, your clerk, your CAO will often warn you. They're doing that not to irk you, but to try to protect you, okay? And just remember, you may be able to deviate a little bit, right? But just be careful about whether the matter is inextricably connected to what you're talking about. Please adhere to the closed meeting voting restrictions and limitations. Your clerk, your secretary, if it's at a committee meeting, has to keep a good record of the closed meeting. I've given you a guideline here. Please try to report out as much as possible. I think it is good practice for an open, accountable, transparent local government. And I think I've said this in the prior training, never, ever disclose closed meeting information. Your professionals, even though as members of council, you are generalists, right? You may have some specific knowledge about things, but you rely on staff for those things, right? So please remember, just because you may think you know more than others doesn't give you the right to unilaterally breach the confidentiality requirements, which have been held to be a cardinal rule of a municipal councillor's requirements. Again, the leaking of confidential information could open the municipality up to all sorts of risks and liability for damages, injury, harm, and potential costs. You may then have people filing code of conduct complaints and possibly closed meeting investigation complaints, all of which are paid for by the municipality. So, Madam Mayor, members of council, that's the end of my PowerPoint deck. And so I'm going to stop sharing, and I'd be pleased to take any questions that that council, or if you permit, staff may have.
Thank you very much. Found that, excuse me, very interesting and informative. At this point, does anyone have any questions of John to put forward at this time? Oh, sorry, Councillor Heeman. Thank you.
Thank you for that presentation. That was very detailed, and it's a great refresher. I was just wondering about your final comments with regard to disclosure of confidential information. I'm just wondering how that applies to potential land purchases, because at some point one would assume that that information becomes public in nature or self-evident. So is it still best practice to wait on a staff announcement, or is there some, like, how does one best handle those situations?
Yes, through you, Madam Mayor, to Councillor Heeman. The information at a closed meeting and the deliberations that the council undertakes belongs to council. And my comment was that it's not to be disclosed unilaterally by any individual member of council. You may again think it's important. You may even think, and there's been all kinds of closed meeting investigation reports where council members says, I'm the only one here who's looking out, like they're not doing things appropriately. They shouldn't have gone in camera to begin with. And the point is, you can't make that unilateral decision. There was an early decision by Lawrence Sawson, who was the closed meeting investigator of the City of Toronto. He said, the decision on whether to breach confidential information rarely is something that is undertaken as a matter of choice, because you as members of council have an obligation. But Councillor Heeman, to your point is, if council decides that it wants to disclose what you've discussed in a closed meeting, that's council's prerogative. And at some point, you're right, it's going to come out. But what comes out that maybe the land was, decided to be sold to this person. But what doesn't come out is maybe the land was, subject to a lot of debate. These people, these members didn't want to sell it to this person, or there was mistrust of that person, or there was, someone else, that kind of stuff all remains confidential. All of that information belongs to council when council receives that information at the closed meeting. It's not to be disclosed unless council decides that it's going to be disclosed. Staff itself can't disclose it. It has to be direction of council to do so.
Okay.
Good. Anyone else with a question before we leave this part? Seeing none. Well, thank you very much, Mr. Metzger. It was really a good session. Thank you.
Madam Mayor, thank you again. I really do appreciate the opportunity to appear before you. Thank you very much for your attention and for the time that you've given me. Once again, you're going to hope that you don't see me the rest of the council term. I'd like to see you at some point again, but I understand the sentiment. But again, I wish you much luck, and I'm around if you need any advice. So thank you again for today.
Thank you. All right, council, will move on to the next portion, which is the consent agenda. Items listed under the consent agenda are considered routine and may require discussion, but no action on the part of council. Consent items are received for information in one motion. Council members may request that one or more item be removed for further action. So the recommended motion before us is that the minutes of the special council held on December the 19th, 2022 be approved as circulated, and that consent agenda items 6.2 be approved as recommended, and that consent agenda items 6.3 through 6.2 be received as information. I'm sorry, what did I, 6.2. Sorry, read that wrong. Did I really screw that up? Did I? Okay, and that consent agenda items 6.3 through 6.12 be received as information. Do I have a mover or Deputy Mayor?
I can move that. I would like an opportunity to just make a couple of comments if I can.
Absolutely.
Once you get a seconder.
A seconder for them? Councillor Lockie? All approved?
Just a couple of comments before we call the vote. I first of all, I just wanted to indicate to council, I did talk to the clerk ahead of time. There will be some further reports as it relates to the municipal election coming forward, which will be good to see in terms of some of that information that's been provided by IntelliVote. So that was good to hear. And secondly, as it relates to the financial indicator review, I think kudos to all of our staff in ensuring that we have such a pretty positive report on our financial status. So thank you very much.
Yes, we do. And thank you very much. All right, so I will then call the vote. All in favor? Any opposed? Seeing none, carried. Next item, we'll go on to our reports from the departments. 7.1, operating and capital budget. We have a recommended motion that report number F001-23 be received as information, and that development charge reserve balances be approved as required in accordance to Bill 23, the More Homes Built Faster Act 2022, as per the attachment to this report, and that bylaw number 3-2023 budgetary estimates be adopted by council. Do we have anyone speak to this? Kim, go ahead.
Thank you, Your Worship, and through you. Report F-001-23 is before Council and provides budgetary estimates for 2023, as well as allocations of parkland in lieu and required development charge reserve funds in accordance with Bill 23. The 2023 final budgetary estimates after deliberations include a tax levy of $11,790,014, 2023 capital projects of $15,213,469, and prior year capital projects that are continuing into 2023 in the amount of $5,843,141. The resulting local municipal tax rate increase calculates out to 1.065%, which is a tax levy increase equivalent to 3.43%. Reserve allocations included in the report for services related to a highway, wastewater, water, and parkland in lieu are sufficient in meeting the spend and allocation requirements under Bill 23. If there's any further questions or comments, I'd be happy to address them at this time.
Anyone have questions? Okay, at this point, I'd like to ask for someone to move the motion, please. Councillor Lockie, seconded by Deputy Mayor Smyber. All in favor? None opposed? Motion carried. We'll move on to 7.2, PDS 001-23, disposal of surplus lands, 2637 Dorchester Road. We have a recommended motion that report number PDS-001-23 be received for information, and that the sale to the purchaser of the subject lands having an area of approximately 0.4 acres located at the rear and north side of 2637 Dorchester Road, valued at $20,000 per acre, be approved, and that all applicable surveying and legal costs be at the expense of the purchaser and due at closing, and that the net proceeds of the sale of the subject lands be directed to the Community Services and Facilities Reserve to accommodate future capital projects. Do you wish to speak to this, Mr. Bancroft?
Your Worship, I'm here to answer any questions. I think my report is pretty straightforward. Thank you.
Thank you. Anyone with questions? Okay, seeing none, then We'll ask for someone to move the motion. Deputy Mayor Smyber. A seconder, Councillor Crockett. All in favor? Motion carried. Moving on to 7.3, PWES-001-23, Thorndale Mobile Home Park Water and Sewer Charge Agreement. Recommended motion is that report number PWES-001-23 be received for information, and that bylaw number 7-2023, being a bylaw for the provision of both municipal water and sanitary sewer charges based on the amount of water consumed by the Thorndale Mobile Home Park based on the municipality's fees and charges bylaw be adopted as by council. Mr. Craven, did you want to speak to this?
Sure. Thank you, Worship. Report PWES 001-23 deals with the upgrade of the metering method for the Thorndale Mobile Home Park. This method eliminates required upgrades and ongoing maintenance and billing costs by eliminating individual meters and replacing them with a centralized meter. If you have any questions, I'd be happy to answer them.
Are there any questions? I don't see any. So at this point, may I have someone to move the motion? Councillor Heeman? A seconder? Councillor Lockie? All in favor? Motion carried. Report number, item number 7.4, Flight Exec Center Expansion Ad Hoc Committee. We recommend a motion that report number CS-001-23 be received for information, and that council reestablish the Flight Exec Center Expansion Ad Hoc Committee, and that council approve the attached terms of reference for the FCEAC, and that council appoint 2 council representatives to the FCEAC, and that staff be directed to contact former community representatives to confirm interest of reappointment, advertising in local newspaper, website, and social media as necessary, and that the clerk be requested to report back to council concerning the outcome of interest from the community representatives. Mr. McDonald, are you speaking to this?
Yes, thank you. Good afternoon through you, Your Worship. You have report CS-001-23 before you with all those recommendations, basically just being the logical next steps to proceed with this project now that it was approved as part of the 2023 capital budget. So in addition to the recommendations, just wanted to touch on the fact that the committee does not include as active voting members any municipal staff. The municipal staff that serve that committee are there as support members, providing information, helping create and administer the RFP process and the like. Reestablishing this committee will formalize the involvement of council and community as we move forward with the project. And I would report back to the committee on the impact that this design build project will have on various operating budget lines, mainly those being program and rental revenues, once the project's been awarded and we have an idea of the timeline for the schedule, because it's at that point that we will have a better idea of what sort of impacts there will be in those regards. And I'm happy to answer any questions you might have.
Does anyone have any questions? Deputy Mayor Smyber?
Thank you. Since council had made the resolution in terms of the recommendation that came forward from staff and the amount of money that was put into the budget, I have had discussions with some committee members expressing concern with the fact that perhaps we didn't have all of the information available before we made our decision. I don't disagree with that, but I'm hoping we can find a way forward. I think this resolution can do that. I want to make sure that the representatives that were on the committee they keep on the committee, because a lot of work has gone into those discussions and what's really needed as part of that renovation. I do note as well, you know, we're taking a look at a budget figure which is a bit less than what the RFP had come in at. So I think this resolution gives us enough flexibility to take a look at, you know, I don't want us to throw out the hard work that's been done by the committee. I'm hoping that we can use that. And if there are some areas that we can cut so that it can fit into the budget, then that's great. But if not, I just want to make sure that we're doing this right. So if it makes sense for them to come back with the original proposal, like I want to take a look at any and all proposals just to make sure that we do this right. And I think this resolution does that. And we've talked with staff before the meeting, and staff confirms that is probably the best way to go, considering the circumstances that kind of got us to this point.
Thank you. Does Councillor Heeman?
Yeah, I would agree with Deputy Mayor Smybert's sentiments. I just want us to, again, do this right and not lose any time that lose any time in the execution. We have a lot of effort that's been put into this, and I think that through our existing RFP program, we can go back to the applicants and not lose some of that traction. So I'd like us to see some forward momentum, and although we did change the parameters, I think that we can still move forward quickly.
Thank you, Councillor Heeman. Anyone else with a comment or question? All right, seeing none, do I have someone who would wish to move the motion? Councillor Crockett, a seconder? Councillor Lockie, all in favor? Motion carried. Thank you. Next item on the agenda is the mayor's report in council. Because of the Christmas break and everything getting going again, there's not a lot to report. On Friday, though, Councillor Lockie attended at the all-inclusive park to accept a check from Doug Terry Holmes for $5,000 towards the project. In attendance were Mr. McDonald, Devin Brown, Sally Pepper, and the representative from Doug Terry Holmes, along with Councillor Lockie. At the same time, I was at a SWIFT announcement. This is for connectivity within the municipality. There was a large presence there. Rob Flack as our member of parliament. Peter Fragiscatos from London North, MP Karen Vecchio, Dominique Giguère, the Mayor of Township of Malahide, Kathy Burkhart-Judson, Warden of Middlesex County, myself, Joanne Vanderheiden, she's the SWIFT board member and chair, I believe, and Melissa Greco from Explore, Manager of Government Relations and Stakeholder Affairs. It was held at 3542 Putnam Road in Mossley on a very, very windy, chilly morning. We went into a drive shed that was well ventilated and had our announcement there. Other than that, I will be going along with the deputy mayor on Wednesday morning to attend a breakfast meeting to which the Minister of Finance, Mr. Bethan Falvey, is invited. I think that's it for my report at the moment. So is there any unfinished business that needs to arrive? None? Okay. Notice of motion? None? Any new business? Okay. Council will be now moving into closed session.
Sorry, can I request we take a 5-minute break before we go
Certainly.
into closed session?
Certainly. All in favor? I'm sure. All right, 5 minutes then. So that will allow us to reconvene at what time? About 10 minutes to 3 then. Thank you.
Chantel and Tom, are you guys there?
Not sure if council can hear. Oh, you can. Don't look at the TV. Sorry, Sharon, Tina, and Mike. I just sent through a note. I have a hard stop at 3:30, so I have to jump off. I apologize for the late notice.
Councillor, we just maintained that if Steve doesn't speak to the report, we'll get out of here on time.
Okay.
And Tom, what's happened with Tom?
Councillor Heeman, can you turn on your camera, please?
Was just changing a diaper.
Ooh, good. That's what I like, a real man. Okay. So at this point, I'd like to ask for someone to move the motion to go into closed session. Okay, Deputy Mayor Smybert, seconded by Councillor Crockett. Thank you. Carried. I guess all in favor. Thanks. We are reconvening the regular council meeting, and the time is 3:45. During closed session, council discussed personal matters regarding committee appointments and organizational review, and provided direction to staff. We'll proceed now to bylaws, item number 14. We have a recommended motion that bylaws 1-2023 through 8-2023 be adopted as present. All right. We'll leave it that the items are marked on the agenda. If anyone has anything that they wish to address on any one of those items, you can do it now. All right. Okay. So Councillor.
I'll move that resolution.
All right.
To adopt the bylaws.
May I have a seconder for the motion, please? Councillor Lockie. All right. All in favor? Motion is carried. So the next meeting will be held on Monday, January the 30th at 5 p.m. followed by another meeting Monday, February the 13th, again at 5 p.m. At this point, we will call for adjournment and a motion to adjourn the meeting at 3:45 p.m. on January the 16th. Someone to move the motion? Councillor Lockie, seconded by Councillor Heeman. All in favor? Thank you.